Yes.
Sorry.
Yes. Give me.
Petitioner Lord was awarded a tender for supply of ration packs.
You appear in tender matter as well.
I
Achha.
try to.
Instruction in this matter partly, Miller.
Partly?
Miller.
What?
Because, Miller, there are some administrative issues, funds were not available.
Sir, if there was no administrative issue in awarding a contract, in execution of a contract, how can there be an administrative issue in release of the payment? What are they doing?
Petitioner is an MSME. He is in.
Sir, we observed in your favor, sir.
May I bring that?
No praying. We are directing him to make the payments. Whatever the money is to be given, you have to make the payments.
65,37,108. 65 lakhs 37,118.
So let them, they have to collate the entire invoices and all everything, and they will have to make the payments. They can't. Can you show me a document where they have admitted
Your Lordship would appreciate your Lordship.
that they have not raised any
Page
objection?
29, Lords. Page 29,
Yes.
which is the consignee receipt and acceptance certificate at the top of at page 29.
What is this certificate?
This certificate, my lord, is certifying, my lords, my supply in the first invoice at Annexure
Only
26.
thing is that whether they have checked the quality of the
They have
materials,
accepted
everything.
prior to giving out packs. Ration packs are given to the SOG units. If they have tested my supplies, and after they have tested my supplies, they gave me the supply order. Pursuant to that, my lord, I made several supplies. And each supply, my lord, if your lordship kindly turn to.
No, I have seen the invoices.
My lord.
I have
And
seen the
page
invoices.
29, my lord, is the consignee acceptance certificate.
No, that is why it's the very unique thing I come to
My
know.
lord.
That is the consignee receipt and the acceptance
So that is-
certificate. Normally it is not done. That's why I'm asking.
So far as the commandant is concerned, my lord, they issued this, my lord. So that's and the second, my lord, is at page 33, my lord, if you could see. Another acceptance certificate, my lord, at page 33.
Yes.
And then thereafter 37, 41, 45. All the four, including, my lord, the last supply of 1,200 from 18, my lord, was accepted by them.
This is before the supply is made, this issue certificate or after the supply?
After the supply is made. I give the supply, and this is given as an acceptance certificate of the supply. Your lordship will kindly see. This is given by one.
But they did not raise any objections after that.
No.
No.
And this was done way back in 2024.
Uh, Sir, once the list is rolled on, come to
Number two,
Government hand, which was used by the petitioner, the fair place.
why this, you have already taken a zero tolerance policy, you indicated on the other day, then why these are not done?
Millet acts as different in this case, lot of
Achha.
kindly have it. Plans to page 33.
Okay.
Actually, Millet, OPAD eviction proceeding was initiated in the way back into 2000 Millet.
Okay,
And thereafter, the aggrieved persons, they filed the civil suit before the civil court for declaration of right title interest basing upon adverse position. And another
against the government land,
against the government land.
interesting, then
And
must have been dismissed,
My lord, another prayer was
suit,
another prayer was made, my lord.
so,
My lord, another prayer was made to declare that proceeding is illegal. And ultimately suit is dismissed.
so
That suit is dismissed.
when it is dismissed?
And it is
Oh, in month
the
of
month of May 2025.
recent, yes, page 38, I see. Then,
After dismissal of the suit, my lord, they have filed a regular fast appeal for current district.
yes.
That is pending.
Any interim order staying the operation of the proceedings or injuncting you from proceeding?
That instruction.
If it is not there, then how can you just sit tight over the matter?
No, definitely. That
So-
instruction I will obey.
This is what our amendment was brought into the CPC under Order 41, Rule 5. We are filing an appeal, does not tantamount to stay. So
Let, I will take instruction, let's see, call on this matter Monday.
what instruction? Proceed with the matter. In the event any order is not there.
Yes.
Yes. Uh, yeah. Bench, you should know that the documents which is in vernacular language, we don't know. We don't have any, I would say, knowledge or an expertise to read a single word.
That is in vernacular.
The-
Yes, 40.
I have seen that. My brother also pointed out.
Yes, correct. The names appearing in that remark column, where the encroacher proceeding is initiated against all people.
The
Item number 3.
My lord, pardon, my lord. In this case, my lord, petitioner, telling the inaction of the opposite note 2 and 3, which not demarcate the public road and not doing drainage system in the public road. For that reason, more than two.
Drainage system in the public road or by the side of the public.
Sorry.
That
Side of the
says so.
public. Sorry.
Ah.
The side of the public road, my lord.
His grievance is the OP number 7, namely Amulya Kumar Behra. He has encroached upon the land. That's why there is waterlogging issue in front of the village school, Miller. Steps are taken, Miller. And the OPLE proceeding under the OPLE Act has been initiated.
But till that they are suffering.
But there was already a existence of a drain or there was no drain system in place.
No.
Because once you elevate the road, then naturally the rainwaters or whatever the water that goes down. And unless you channelize it so that it can go, it will create a flood or a waterlogging.
Let's hope that drainage system is functioned. I am not having that.
Because there another ancillary grievance is for construction of a drainage system along the side of the road. So you'll have to take a decision. You are a civil body. Civil amenities you should provide. And it is one of the, I would say, the integral part of the right to life. Right to life means the right to live with dignity, with all civil amenities.
Anytime I got 700 school to the student in the school, my lord.
So why school? Why not the whole village?
Whole village also, my lord. More than 2,000 people is running this road, my lord. 2,000 people every day, my lord.
Running the road.
Yeah, because there is a sea, my lord. Fishing is doing the villagers in this same road, my lord.
Yes.
Let's so far the enforcement is concerned, we have.
No, yeah, but it's a twin prayer. Not
Not
only the encroachment, also the drainage system to be given. Why don't you, is there any municipality or a municipal corporation or
Coming under a gram
corporation?
coming under a gram panchayat.
So it's a duty, what to do? There are cultivable land by the side of the roads.
Yes.
But gram panchayat is they have not added the gram panchayat party.
I mean,
So who will construct the drainage? Gram panchayat or what?
my lord. Collector is the main authority in this district.
He may be an executive officer of the panchayat. But after all, it's a gram panchayat who will take care of it.
Gram panchayat and block development authority. Gram panchayat has to take a decision on that. By convening gram sabha.
Why are you not making them a party?
I have a party in district page. Tahsildar also I have party.
Are you restricting the prayer on encroachment or you wanted to do it drainage also as a part of?
Both, my lord. Both have drainage also is
You
very
have to
important.
include a panchayat as a party, otherwise
Yes, my lord.
it is brought into the petitioner to add the.
Last notice will go. The private opposite party, Amulya Kumar Behra.
Up to respondent number appearing for opposite party's number.
Opposite party number 125.
1, 2, 3, 4, 5.
1, 2, 3, 4, 5, and 6 million.
7, the notice would go.
Notice would go.
Yes.
Item number 4.
Relating to short lifting of 180 ml. What are your lordships about that?
Not lifting. Yes. They will make up. They will deposit all the money.
180.
Not an MGQ.
And 180 ml.
What? No.
Lifting of 180 ml.
So this is another matter.
Yes, ma'am. 180 ml.
This is 180 ml.
180 ml. Power.
You just find out the day. You will sit one day and then dispose of the matter. We can't keep it eternal. Yeah.
Item number 5.
Yes, please, ma'am.
I come to impress upon the government who does revisit the policy.
Yes, please, ma'am. This is a tender, my lord, for transportation of coal.
Transportation of
Coal.
we
Coal.
have a coal mines here.
Yes, Singri coal mines. It operates in Onugul, Dhinkana. That area where, my lords, Dhenkanal Anugul area on the way to Sambalpur. That's where MCL mines are there.
These are more, they have a bauxite deposits more than gold. That's why I'm asking. I know this is Jharkhand.
Jharkhand is there.
Bengal, I know.
Bengal is there.
Huge gold deposits are there. My brother shares that in Assam also.
We also have huge deposits.
You have.
MCL also huge deposits. Sambalpur area, Brajraj Nagar,
So
Sambalpur
this is
area.
for transportation of a coal from a mines to a siding.
To the railway side. You'll actually find that at page 27.
What happened? This is the problem.
We qualifying all the technical requirements, save and accepting, they have introduced a new clause this time. And we have to furnish a site
visit certificate, that clause your lordship finds at page 28.
You'll have to visit the site first.
My lord. And the site visit certificate has to be given by the general manager of the same coal mines.
Okay.
Now, we have done the site visit.
So a site visit of a coal mines or
No,
a railway
of the area through which the transportation is to be done.
Okay.
This is there. Participating firms, it's a short
Where, which page?
page 28. Participating firms are required to visit the mine and the villages.
Where?
This is page 28,
I'm looking at F.
clause F.
Say that.
I'm sorry, Manas, clause F.
Yes.
Participating mine firms are required to visit the mine and the villages en route to the railway siding. During the visit, they must assess the condition of the roads, local condition, and any concerns raised by the villagers, including the prevailing practices for engaging trucks from local transport associations. Further, firms must evaluate the feasible number of trips that can be operated between 9 p.m. to 6 a.m., accounting for the daytime operational restrictions. Following the visit and assessment, the participating firm must obtain a site visit certificate from the general manager 90 area. This certificate must be submitted along with the bid during the participation in the tender. Failure to submit the site visit certificate will result in the firm's offer being deemed non-compliant and the offer of the firm will not be considered.
True.
Now, this is a clause, my lord, which was introduced for the first time in this tender.
Because of you moving lot of read matters before this court. Road conditions are very bad and we are unable to, we have written to the authorities to give us smooth passage, remove all the borders from there, give a pitch road. They said, first you accept it, be satisfied that what you can do.
My lord.
It's a very good reason.
Well, while that's a very good reason, my lords, we have done the site visit, page
Oh.
148,
Yeah.
annexure 6. On 14th November 2025 at 11:13 a.m., we have given them the email. Our representative Vidyadhar Behra, bearing Aadhaar number so and so as per tender requirement, have made a visit to the Naini site and assessed the condition of the roads, local conditions and other concerns raised by the village. We have also assessed the desired requirement of engagement of trucks for transportation of coal from Koliyari to Kamakhya Nagar and Hindol Road railway siding, along with the required daily trips of coal quantity over a period of 2 months with operational time restrictions. After completion of the site visit, our representative, Mr. Vidyadhar Behra, approached your office for the site visit certificate.
What is the last date of submission of the tender?
My last submission was 15th.
15th.
15th was the last date of submission. Now it has been
15th of
extended.
November.
Now they've extended for
15th of
November.
So-
Now it has been
so
extended for
you
3 more days.
You write to them on 14th of November.
14th. Because the tender was floated.
As
That's-
the faggot.
No, the tender was floated. Your Lordship will see.
When
Tender was floated on 8/11. 8/11.
yes.
So it was a very little time, so we organized everything. And this was, we had kept it till the last, that we will do the site visit and they'll give us a
And
site
then
visit.
you submitted the bid.
No, we have submitted the preliminary bid, that they'll not consider it, they'll throw it.
No,
throw it
no,
out.
that I understand. That
That
means
bid has been submitted.
without any certificate. Your
Man, without any
allegation
certificate.
is that I have asked for, you have not.
You have not given. That is. Photographs are there, our representatives have gone and they're waiting in the
With the
site.
date and time.
Month.
Photograph.
Photographs, no date and no time,
Ah.
but our emails are there. Emails are there. Emails are there, email has the time. Email has the time.
Yes.
We have been informed by a representative that your office has declined to issue the site visit, citing no reasons for such.
No, that I have already read.
Month.
I have already read.
Month. And then again at 3 minutes past 1, we have given another email. Then on my lord's 14th itself, we have given them a hard copy of the letter. And then again on 15th, At 12:40 PM, my lords, we have given them another email. That my site visit representative had gone yesterday, you did not give, again today we are waiting, you are not giving us. And without this certificate, we will not be allowed to be considered for the tender.
Yes.
Now, my lords, on that declining, we have 2 days, so we filed the writ on my lords on 17th. We took 1 day to prepare
They
the
have extended the time.
till tomorrow, 18th.
Why? For such a short period of
Man, that is the whole difficulty. Now, what we have been informed is that they have certain fixed bidders in mind who they will want to give. That is the difficulty, my friend. We can choose. Completely arbitrary
Is-
clause,
is
there are no
for-
objective
is for-
markers.
This for
If they notice has to go to Anupul Manas, we'll take notice of special messenger. They don't have a retailer.
who is the authority?
Authority is Anupul. But authority is Honorable General Manager Contract Management Singari Colliery Limited at Naini area, Vikas Nagar Road, Honorable Odisha. Then he is the authority, man.
Angul.
Angul. Angul is not Singari. And after, man, interesting. After receiving my email, they have given us one more mail. They have given a reply where they have added 3 more conditions. That also we have complied. Your Lordship may kindly have that, Maladi. On 18th. On 18th itself, your Lordship will see
17.
Last date is?
18th.
So that has gone
Extended yesterday again. Yesterday, there was another extension yesterday.
till
We are not aware, but extension has been done. That's
not be done, sir. You are pushing for an interim order without anything. How can we proceed on that
There's
basis?
an extension. They've also extended it. They've added 3. It's also not a part of this document. That also we have complied.
Come to the last page of the article.
Madam.
Last sentence. Last sentence. Page 17.
17.
Last sentence.
Madam.
What is the meaning of this? Next verification due on 26 November. That's why I'm asking. What is this? What is the meaning of this?
This is issued by the government of Orissa, not our document. This is to the
This is internal communication between the department.
Department of Communication. Certificate of verification of the
Even this doesn't form a scope of the work, which is here.
Where is the reply?
reply is here. Page 7. To Service Communities Private Limited. Dear sir, tender number so and so. With reference to your trailing mail, this is to inform that we have noted the contents of your mail wherein you have stated that you have fulfilled the requisite procedures of site visit and evaluated roads, conditions and practices. However, it is not clear if discussions have been made with villagers en route and with local transport association for clearance of movement of trucks. We wish to inform that production of coal in Naini area has started in the month of May 2005 and further stopped due to non-dispatch of coal. Earlier orders have been placed.
But these were not the conditions. It was only.
These 3 conditions were not there. Document certifying proof of ownership,
Are you
partnership.
sure?
Man, this is not there.
It has to come by way of.
That's the only F is the condition?
Only if it's the
There is no question of any proof of ownership
consent
of
to
partnership.
of a
There is
corrigendum.
no consent to operate respective railway signs issued by the State Pollution Control Board.
No, there is consent. We have downloaded it and we have complied, these three. These three are conditions which should be
But
complied.
they were not initially incorporated in the bid document.
No, they were not there. They have to come by way of a corrigendum. And this is not a corrigendum by any stretch of the-
So many questions are put only to get that.
Well,
Whether there was any correction.
No, there was no corrigendum. There was no corrigendum. It has to come by way of a corrigendum. No objective markers, nothing.
The petitioner is an intending bidder.
Second is another tender. Second one is also same tender on the same site. Yeah, not on the same.
The tender is floated by an authority, citus whereof is
HON'BLE.
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 What is it?
This is for the HON'BLE site.
It comes under Telangana, that's available at case 22, as well as case number 23.
83. Registered office may be there, the entire work is here.
No.
Site is HON'BLE, the department is Page 86. Page 86, your lordship will see, sealed tenders are invited for transportation of coal from Naini open cast project, Indore.
Tender is floated by the Telangana government.
No, it's not JV company. JV, it's a JV company.
It is in HON'BLE. Anyhow, sir. What is the next one?
Next one is another site. Same plot.
Another site means two tender.
Two tenders were floated. Same
Other site is
Kamakhya Nagar goods shed, Naini area, Kamakhya Nagar goods shed, two mallards. Yeah, page, no? What's the page?
Really open. This is a handling from a shed to a railway.
Shed
siding.
to the railway.
Railway siding. And this is in HON'BLE also. See,
HON'BLE.
show us that you have given an email.
Well, here also same page 148, page 148. Page 148, same email, man, annexure 6. To the general manager, Singheri Colliery Company Limited, tender number 1
Same.
Yes.
Only the difference will be.
Tender number ID will be different.
This from Colliery to. For what purposes?
Yes. Yes.
Yes.
Item number 6.
Okay.
Yes, jurisdictional assessing officer, you also initiated 148% instead of restless manner. Same.
One. You checked?
Now, back to my lordship's sake.
Yes. Yes.
Item number 7.
Make these. Yeah, billets and challenging the order in original billets. Interest billets prior to this order in original. Way back in 2023, there has been a discharge order that is issued, which says there will be no further proceedings for short payment of tax under section 73 of the Act. Here, billets, if I make
Is it 73 or 74?
73. The originally what happened, Millers, I explained. There was a search that was conducted in 2022 Pursuant to the search, I made a voluntary disclosure that 92 lakhs is the amount. That 92 lakhs was ascertained, accepted by the department, Millets, at page 27, Millets. Yes. 27 is the order. Millets will see. It is dated 27/6/20.
What discharge from further proceedings under section
73 for short payment of tax. And your lordship will kindly note the period. It is for the period July 2017
to March 2020.
2022. My lords, when I am discharged for section under section 73, and this is, my lords, pursuant to a search. That's the highest level of inspection that they could do. And there, after I got this discharge order. Now, my lords, there was another proceeding that was initiated. Your lordship will kindly see page 83, the show cause notice.
Yes.
My lords, I'm just showing, my lords, page 83, 5/11/2024. Your lordship will see the period, tax period, April 2020 to March
2021.
That is penalty.
That's covered under this.
Yes.
That's
And-
covered under this.
And my lords will see the rules under section 73. And your lordship will see the grounds. Point number B, short payment of tax.
Yes.
And this is the show cause notice, which I also gave a detailed reply. I also relied on section 62B of the CGST Act and OGST Act is pari material. My lords will take 62B. It says, a proper officer under the CGST Act has initiated any proceedings on
Then
a
the state is denuded.
Yes.
That is what we also,
Yes.
one of the matters we have said.
My lords.
That you can't.
So that
The question was who has initiated first?
the CGST millets and given the
Question
discharge
was
order.
that who initiated first?
Yes,
And what is the starting point of a initiation?
that was by way of a search, and there the discharge order is issued.
Correct.
While that is so, millets, now millets, your lordships will kindly take page 105, the impugned order.
Huh?
Page 105, millets, the impugned order.
Yes.
Assessment order. I am reading at the very top below.
That is period is,
Two,
that's the, sorry, what is the date of the order?
14 to 25 millets.
14?
To 25.
Where do you think?
Let's see, your lordship will find at the
Page 100.
100, page 100. So grateful.
Yes.
Now, let's see, that is the form. Form starts at page 100.
No,
The
I
description.
understand. That's how we wanted a
Yes.
date.
Millet's page 105. This is
Isn't
an
it
asset.
something different. That's why I wanted a rating. We are grappling with one situation.
Yeah.
You also know.
For that, I am silent, Your Lordship.
That's okay. The fact remains, Millet, it's a That's right.
I am, yes, I am inviting you to address everybody. I invite. The problem is that paragraph. Mr. Kaur is, he's really, withdrawing himself from there, not, not working, so seriously over this point. What to do?
Let's play.
He will be taking that, I know,
Yes, let's.
but apparently.
No, apparently there is different subject matter. 6 does not apply. I'll convince and I'll
When the,
counter.
when the discharge under section.
No, your lordship, that discharge is only for short payment. Here the subject matter is
But
different.
your notice says.
Notice, your lordship, only the notice
Short payment
heading.
tax. What does it mean?
Only the
Short payment-
notice heading is there. He has not enclosed the detailed notice. So
Oh,
I'll
written
come.
notice has no-
I'll come along with all the evidences and the detail of counter. I'll come, but
Know this formidable.
But the prima
opposition
facie-
You have to face.
I'll.
only the
He will-
prima facie
will-
I have stopped
He will
down.
not, he will not go, allow you to go merrily. Have to. But you'll have to satisfy.
Let's be satisfied. Let's be.
Keeping this on, board.
Yes.
The point involved in.
In the meanwhile. Plus, I'm in a lordship time, whatever lord.
Item number 8.
Great.
Yes, appearing on behalf of Mr. P.K. Harichandra, senior engineer. This is a matter regarding non-constitutional GST tribunal.
There is no taxation in the general life. Is there any taxation in the general life? General taxation?
If an interim order may be given, because this is already covered by your lordship's order.
No words, I mean.
I'll bow
Right to know.
down. Lordship, I keep it for Monday, your lordship.
Yes. Praise for a service of the copy. Copy to be.
Item 10.
This matter requesting cancellation of elections.
Yes, your check. Yes. Next.
Item 11.
Item number 11 by right, that is two items. The very first item, I am praying for a direction to the opposite party to execute the agreement, as I have been declared at this.
Can we do it?
Pardon me, madam.
Can we do it? What is there? That's their decision to accept the contract to be extended or not to be. Court cannot be a party to a
No,
contract.
madam. Contract has not been awarded yet, my lord. Only the tender was floated. I have participated. I was declared a successful bidder, and the letter of award has been given to me. We are not executing the agreement, my lord.
The second tender has been cancelled.
This tender.
Yes, this been cancelled. And this tender, you know, if they are going to take a
Second
decision
tender has been
today.
cancelled. This tender was issued. I am concerned with this tender.
This tender today, they are having a meeting, your lordship, and in a week's time, we'll be deciding on this tender today.
Say construction next week. Wednesday.
Oh, bless you.
Item 12.
Item 12, I am on BC. In fact, I am mourning, performing obsequies of my mother. That's the reason. If your lordship would kindly see, I have suggested little corrections in the judgment.
Comfortable in arguing, or you are in bereavement, so you want this matter to be fixed somewhere after we complete all the rituals?
As your lordship, but just minor,
Up to you, Mr. Law.
the minor corrections, my lord, if your lordship can just see it, my schedule, I have suggested some words only.
What?
The schedule in my petition I have given, I have only suggested some words so that just little correction in the words. So, page 5 of my application.
I have for modification of the order.
What judgment we pass? What correction?
Lord, if your lordship would see, just only the word in the 6th line, your lordship has been pleased to say unobjectionable. In fact, this para 2.4.
No, where is the judgment now?
That judgment is annexed to my petition.
Page
6
6.
of the IA.
IA.
Page 5 of I.
IA. Which paragraph?
Lord, page 4 of your lordship judgment, para 2.4. 6th line.
Yes.
6th line, my lord, I have suggested your lordship would kindly see the word on a government is an unobjectionable place. Lord, I was also suggesting at the time of dictation, I did not disturb your lordship. This unobjectionable word should be substituted by relaxable. The reason being, the site which I have suggested is 420 meters from a school. Government is agreeing to relax it. In the order itself, government has also agreed to relax it. So that's the reason that if the unobjectionable is written, then it.
Sorry, I could not. I think your submission was that you gave me a particular paper.
Right.
I correctly remember that these are the 3-4 sites I gave
But
you.
you're right, Lord. That last one.
Then you said that the last one which you have suggested, the government is not objecting.
Lord, last but one. I remember it. But probably there is a communication gap. Last but one site. Last site is rejected.
No, I do not. I have simply used the word one site.
No, in the judgment
One
part,
site, whatever.
if lordship would kindly see para 2.4.
Yes.
The government, Lord, kindly, I am reading the sentence. However, one site suggested by the petitioner, though appears to the government, is an unobjectionable site.
Appears government is an unobjectionable.
Right. If lordship would see the impugned order, government in the order says that it can be relaxed. It's an objectionable site, but can be relaxed. That's all. In the counter, they have also admitted it can
I
be.
do not think so. It's a government who should come and say that this is not an unobjectionable site. Then why you are coming up?
As your lordship, please, my lord, if the government on this grounds. As your lordship.
No.
But there are other little suggestions if your lordship would kindly see, my lord. Kindly see. At page 7, lordship may see. Lord, I'm sorry, I'm disturbing your lordship, lord. Kindly see, lord, page 7, para 6, 5th line. The site which I'm suggesting now, government allowed it, is the last but one site in that chart itself, not the last one.
Yes.
The site in my chart which government has agreed is in my chart which I have given to before my lords, my lord.
Yes.
That is last but one site. Last site.
I have used one site. I have not said only one site. I say it may be out of 5, 1.
Kindly say, my lord. That
We'll ask for one or a preceding site or something of that kind. We have
Ajay.
said that one site is unobjectionable.
Yes, my lord.
No, it
That
may-
will do. That will do. That will do, man. I'm sorry, my lord. That will do. That will do.
I'm not saying which site.
Fine, my lord. Let it remain, my lord. Lordship may dispose of the IA, saying that if the government finds any objection, it's for the government.
We proceed with the IA or should we dispose of?
No, my lord, will not proceed. No, will not proceed.
Yes.
Will not. I'm sorry, my lord, I disturbed your lordship.
Memo.
He will give the memo. My lord, I'm sorry, I disturbed your lordship.
No.
Item 13.
Item number 13 minutes, there are two IAs are there. One, both the IAs was according to the subsequent development, and these two IAs were IA for amendment. One IA I would like to withdraw minutes because 12019. I would like to withdraw that IA because after that the subsequent as per the subsequent development, IA number 12685 I have filed. This is also for amendment minutes, and the copy has also served up in my learned senior. And
No, there is a IA you want
I want to withdraw 12019.
Let's see.
This is the-
Let's see. 12685 she wanted to press.
Yes, please.
And which one she wants to withdraw?
12019. Flat B.
One 12019 you want to withdraw.
Yes, please.
No.
And minutes.
The reason is not there. Yes, Mr.
No objection. No objection. Let him.
Withdraw, but what about amendment?
No, amendment also,
Subsequent event.
because she's interested to imprint the rest person who has taken tender, successful tender. Actually, he will be a necessary party.
There is a player in the petition, page 4 now.
Page 4.
In
Page 4.
in the IA minutes.
I page 4.
You want to add and then certain
Yes,
amendment
certain
in
amendments.
relation to that.
Yes, minutes. At page 4 minutes, the schedule of proposed amendment I will.
I
My lord, if not challenge 73 would be of finance act. Matter was listed on 15.
Pending before the Supreme Court.
Matter was
Has it been listed?
Oh, my question is not writing what is listed. Matter was listed on 15. The lordship was pleased to admit, but no interim order was.
I say adjourn Telangai till the decision is taken and liberty was given to both the parties to mention the matter after the Supreme Court decides the matter. And in the meantime, we say no coercive action.
But in the present order, it has not been mentioned no coercive actions. For that reason, the bank accounts have not been reversed. I filed in this case. This case is there. Order
What is this miscase?
for no coercive action. Your lordship have.
Why miscase is registered? Is an application you could have taken out in the writ petition itself. Why miscase is registered here? Is there any provision for a miscase to be registered for that?
By mistake, my lord, one paragraph has not been mentioned in the order. For that reason, the bank account. This is para 4.
More on a procedural aspect than this. In the High Court, there is no concept of any miscase anywhere in the country.
Interim application.
Why the interim applications are within the filed in the main petition?
Along with the petition.
Yes, sir. Are you not realizing what I'm saying? In which case, when he say it's a supplemental proceeding. It is not a supplemental proceeding. It's the interlocutory application in the main matter.
I find it trigger.
Then you say miscase.
That was earlier
Registered as miscase.
No,
No.
it has been. I may be pardoned, my God. I stand. I interlocutory.
In the track, there is a concept of miscase under the civil rules and orders. But the court does not guided by civil rules and orders. His own rules.
My limited way, no pursuit until further orders, as per para 4 of the order.
The court has also granted the stay.
I thought that observation may be made, to clarify.
Where is the order of the Supreme Court?
Para has been quoted, what she was quoted at page 1. In para 2.1, para 2.1, where the lordship is quoted.
No, that's the.
Second May 2025 is reproduced here under. That's good. Bad.
It says that the revenue was paying an interim order, but that was not granted because people wanted to hear about any SSCs. So.
In this SLP manner, notices were not issued.
Issued. And paragraph 9 says that the High Court will stay away from hearing all those matters.
So that's why my lordship has
Yes.
adjourned these matters.
That is what we say, that we can't hear out. No, this is an interim application taken out by the minister seeking for an interim order. Next.
Item number 15.
There is a delay of 51 days. Only delay of
Notice is inevitable, sir, whenever there is 2 weeks, short notice we are given.
Well, in the meantime, in the contempt proceeding.
But why you are delayed? In addition to the usual.
Number 16.
Withdraw, yes, memo file, no entry order. Who is for the other side?
Sir, petition.
Who is for the other side? Government, you are appearing. Any objection for withdrawal? The court consent withdraw.
Item number 17.
Immediately, your lordship. Is a public interest implication matter that are related to Sisu government. This
What has happened? Now administrative building,
Matter.
what has happened?
The drainage system will be controlled.
No, there were two issues, if I correctly remember. It's toward this hospital. But the administrative building has been constructed, so it cannot be made functional because there is no. Has it been done?
You directed the municipality to take steps regarding.
That is what the government last time they came up that because there was really may I use the very loose term, passing of buck.
Yes.
Says not my responsibility, your responsibility, all these things. Ultimately, it falls upon the Cuttack Municipal
Yes, ma'am.
Corporation.
Yes.
Now we directed the corporation to take steps.
Right.
Now what steps have been taken by the corporation?
Nothing.
What are you doing?
No.
Serious allegation, nothing is doing.
That's not that.
I may be permitted to draw your lordship and to last order. Ordering portion.
Sir, we remember. Remember.
The new building, my lord, is functional. That is under the jurisdiction.
How can it be without the drainage system? Their problem lies that yes, it is a 10-storied or a 8-storied. How much?
D plus 6, ma'am.
6. That has come up. We could only made functional so far as the ground floor are concerned. We can't use it because there is no facility for drainage system. So where the peoples will go, so we can't make it functional. Now you were directed to immediately take steps. Last time, I think your officers were also there. If my memory goes right. And they ensured that within certain months, I will complete it. Now that has also expired. What you have done?
The tender process.
You said on the other day also that you are contemplating to issue a tender.
That the tender process is complete, my lord.
Then?
The drainage system is to be constructed in 5 phases. For each phase, a bidder has been already selected. They're supposed to.
Why you are going into a fragmented manner? Why? Why not the full drainage system by one go?
Not because of the.
Because again, phase 1. Then you will again issue a tender for phase 2.
For all the 5 phases, the tendering is over. For all the 5 phases, the tendering is over. Bidders have been.
And a different bidders for all each phases.
5 different agencies.
Can you imagine? One will construct a drainage system, say up to 300 meters or 400 meters, like that. Another will start from 301 and then go.
That's the technical detail of why it was divided into 5 phases I'll obtain. But the gist of the matter, my lords, is that the tenders have been finalized, bidders have been selected. They're supposed to give their additional performance security and EMD before the 30th of this month. And first week of December, the work order will be issued.
102 bidders participated in the entire process, man. That's why 102 bidders participated.
True, when you have invited when you invited a tender, obviously large number of bidders will come.
So that is over. That is over, my lords.
But how long?
The process.
Sir, it's the children for whose benefit the entire infrastructures are coming up.
Well,
and I'm really surprised that the government, with all humility and the respect to in my command, sanctions the plan without the drainage system. Unfortunate.
there was an internal system that somehow had been blocked. So it required an entirely new system to be constructed.
So whatever, sir, if it is clogged, then will you not remove any obstacle?
That is removed.
How? Then why not you join temporarily?
That is what we have to reconstruct the entire thing so it can join. It can join with the main channel for this thing, extraction of sewage. The internal system was catering to only a limited number of people. Now with the new building, there was a need.
So will you not take into account before you sanction the building plan? I think the architect first takes care of that. If the building is to be made functional, large number of footfall would come there because this is for hospitality services. They need the washrooms, they need everything. So all these affluents where you will discharge, then the drainage is inevitable, first thing. And nobody takes care of that. What to do now? Moment it is now made functional, they will say no, certain repairs are required.
Let them file an affidavit indicating the specific date. When the tender will finalize, when the work will be started, when the work will be completed.
Yes, last order.
The last one will be
18/6/2023.
last order is 18/6/2020. Relevant paragraph is paragraph 5, madam. Last 3 lines of para 5 is relevant. May I place, madam? We therefore direct the Cuttack Municipal Corporation to expedite the matter. So far as other issues are concerned, it is open to the appealing parties to mention the matter if the occasion so arises. Para 5. Last 3 lines of para 5. Is a relevant orders.
Para 3, that's it. They say that it will commence from 1st of September. The instant public interest litigation. We have not said. We have given you a liberty to mention if the occasions arise. Was in the month of December, let them do. Unnecessarily directing the matter to be listed in the month of January will not yield anything. In the meantime, if you find that in the first week they have not done it or something, you can come and mention the matter.
That about also the order issued was being raised in this application that has also not been completed.
Which one?
That is the attendant rest measure. Attendant rest measure.
Attendant
Rest shed.
rest. What are you doing?
It is already under construction.
What is this process, sir? How much money it requires?
The attendant rest shed responsibility rests upon the state government, the roads and buildings. The superintending engineer.
Now again passing off.
No, my lord, that is already my
My lord, that is in the process, that will complete. All units you have transferred there. Only the surgical unit is concerned that work is going on and rest shed will be completed within
And my lords in the coordinate bench are actively monitoring that matter. Tomorrow there is a pay.
Then we do not want to overlap in the situation. Anyhow, yes.
Item 18.
Yes.
This is the PL matter which can be disposed of. Can be disposed of. Any more need not be kept pending.
Yes, we will be happy.
What has happened, just briefly let me say. Briefly
Yes.
let me say, my lord, that on the Bay of Bengal, in the Chilka side lake, most of the people, they are fishermen. They don't have the land, agricultural land, all this. They depend on that. But every time they face almost in all seasons, they face the disasters of heavy cyclone. So that is why the government, this is started in Phylini cyclone, that is 2013. Then the government launched a scheme that Odisha Disasters Recovery Project. That means owner-driven houses. That will each of them will be selected and they will be provided 3 lakhs of rupees and 6th installment for constructing such houses, which is cyclone protected. The norm was also given. So in that process, 3,047 people are given. But immediately during the 2020, that money was provided by the World Bank.
World Bank.
World Bank. Then that assistance was given. Somehow it was delayed. Then in 2020, that was immediately World Bank stopped. Then the government has to provide the houses for such persons. So in this process, all the installment already started could not be again disbursed in time.
How many installments were disbursed?
So somewhere 3, somewhere 4, likewise this thing. So then 613 people are left out. Those are entitled to pay. So
That will whether they come within that purview of 3,400.
also one question. So now, my lord, pursuant to the order of this honorable court, that is dated 2/4/2025, the direction was given to the collector to make a verification of this people. And they made the verification and submitted the report. And as per the report, my lord, they have they mentioned that those have been provided houses and as per the rural housing scheme and state housing scheme. That means Indira Awas, all these things, Prime Minister Awas, all these things. So that money is about half of this money because this is 3 lakh, that is about 1 lakh or 1,20,000 or 1,50,000. So that houses are not as per the norms of for cyclone protection because that was already given. So that is why, my lord, your lordship last order, this is the affidavit was filed. In that we have filed the rejoinder, and your lordship will find the last order is. Lordship can have a look at that order, 12/2/2025.
So according to you, no, this half of the amount is not adequate because you have to build a house which is cyclone protected.
Protect. So, my lord, the problem will be solved now. My lord, in the rejoinder, we have filed a document annexed to it. So, lordship will find
What is this?
25/4/2023 that affidavit has been filed. That is-
Rejoinder affidavit of the petitioners in reply to a compliance affidavit.
Yes, yes,
Huh?
yes. So,
Yes.
like, kindly see in that annexed 12 page,
Internal page 12.
internal page 12. Sorry, yes, we start from 12. Then relevant is 14. Paragraph 8. Video Brahmagiri and
Exactly. So it says that those who were already identified under the ODRP scheme, so they wanted that this PMA, Pradhan Mantri Awas Yojana, they will come under that.
whatever assistance is given, if they return back,
No.
they will be provided. Pardon? So far, I understand.
No.
Lordship, may I read it? The video Brahmagiri and Kushikuna block sought certain clarification on the beneficiaries under ODRP who come under the approved list simultaneously were also selected.
Surrender, can be told to surrender the released
Yes.
amount to the government and avail the ODRP scheme.
Yes. If they,
So you say that whoever has come under the PMA,
yes,
Pradhan Mantri, if they surrender the entire amount, then they will come under the ODRP.
no blind. That was only for
And provided no further new beneficiary can be amended beyond the approved list. Means they must be within that 3,400, 3,047.
3,047 already provided. They have
Full.
so far 613 happened. So that has been verified and those 6.
But the last sentence. But what about the last sentence? It is here, it is reiterated by the MD OSDMA that no new beneficiaries can be added beyond the approved list. What is that approved list?
Approved list now, Lord, 3,047, those were already selected and provided.
So
Then next 613, those were only.
now they are the approved list.
No,
They are not the approved list.
that is why for them the case.
Or
For them the case. And
so
that
how
is
it benefits you?
My Lord,
How you
because
benefits?
they are left out. So that is why, as per this,
Now
by
it
the
is a
mandate of
government.
your lordship.
Now the difficulty is, I tell you, the difficulty is that under the ODRP, which is a World Bank funded scheme, they identified 3046 or 3047. I find in the order this figure. Let us say 3047. Now, according to you, the World Bank has provided them the money. They have constructed. Now it appears that in the same area, somebody has been provided a money under the Pradhan Mantri Awas Yojana.
Or other schemes.
Whatever. It talks about PMAY, means Pradhan Mantri Awas Yojana. So there they have been provided the money. They have also constructed their house. Now their house is not a cyclone compliant. Correct. You say that since they are within the same cyclone prone area, there are a recurring incident of a cyclone having struck in that area. So they should also be provided the similar facilities of the cyclone compliant or cyclone resistant, this one.
Right.
This scheme says that if they surrender the amount which they received under the PMAY, then they would be treated under ODRP.
Right, right. Yeah, your lordship, right, absolutely right.
But the
my-
last sentence,
But my humble submission.
but last sentence,
Last sentence, my lord.
that is the troublemaker.
That is the troublemaker can be solved by your lordship.
How can I?
My lord, this is a welfare state. They provided.
It is up to them what to do.
So let them consider this thing,
The
do that.
DRP scheme, the lordship will see.
Understood. They discontinued in the midway. They did not allot you a further money. But as a I would say the welfare state, as a beneficial scheme having taken into account, you have continued. Provided them the rest of the installments. Now, they wanted that some houses were not covered. They were covered under the different scheme.
And those houses have already been
Constructed.
Yes.
Now, they say that if they return back the entire money, which they receive, they wanted this money to be given to them because this money is more than.
Here the question is, had the ODRP scheme allowed to continue, whether they were eligible to be considered within that scheme? If yes, then if your lordship will look at the report.
But their names were not included there.
It was not included because they were not identified along with those 3047, and they were not found as per the stringent condition posed under the ODRP scheme. They were not found eligible. And now, pursuant to the direction of the Honorable Court, a further report has been furnished to the Honorable Court by way of an affidavit. That affidavit, if your lordship may kindly see, that is
what it says.
Your lordship, that is
then what it says.
It has identified persons, those who have already benefited under different scheme. It has identified the persons, those who have.
Then what is the decision which you have taken? Those persons who may have availed the other scheme.
Yes.
Then why this document was?
Because there are persons where the names have been repeated twice or thrice, and the family members of those persons, of one of those persons, they have already got the benefit. And those are the conditions under the ODRP scheme.
No, sir, I could not find the meaning of paragraph 8 of this document which they have disclosed. Issued by the Additional Chief Secretary and Managing Director OSDMA. That's the rejoinder affidavit. Come to internal page 13-14.
This rejoinder affidavit of 2023
must be.
Your lordship may kindly see the latest affidavit which was filed by the state on 11/4/2025, my lord.
Which one?
Pursuant to the direction of the Honorable Court, a report was called for, and the collector
2/4/2025 or what? This is affidavit filed by the
Collector Puri, my lord.
Opposite party number 5.
Opposite party number 5, that is Siddharth Shankar Swine.
Yes.
The lordship may kindly glance to that affidavit.
Yes.
They have made a detailed inquiry in respect of all 637 or all 630, and they have given the point-wise reply to all, everything, my lord. So lordship may kindly see para 5.
Yes.
Para 5 of that affidavit, that it is humbly submitted that modalities for selection of beneficiaries under ODRP scheme.
The criteria then you have said outlined is A, B, C, D, whatever.
These were the criteria.
Yes. Then in accordance with these 3046 beneficiaries were identified.
Yes.
One additional benefice was added. That means 3047.
3047.
Then
your lordship may kindly come to para 6.
Yes.
My lord, para 6, pursuant to the direction of the Honorable Court, the claims in respect of 613 were verified by the BDOs of Brahmagiri and BDOs of Krishna Prasad.
Where?
Your lordship may kindly see the next page, page 5. From the recent report submitted by the BDO Krishna Prasad by his letter dated so and so, it is found that your lordship may kindly see one by one. They have given in details in respect of all these 630.
They have
Yes.
identified these persons and they found that most of them have already availed the benefit under different scheme. Some names are repeated, some are government employees, which they could have never been eligible under the ODRP scheme because of the conditions stipulated. They have given the entire report, and this
And
report
then what is their response to this affidavit?
No, they have not responded.
Sir, we'll have to respond because these are the serious stand taken by them. If you do not come under the ODRB, then how can you be switched over, permitted to be switched over?
But he said,
No.
so far I remember one of the person is Alib, he has said that dead.
No. He simply says that some of them are all the government employees. They do not fulfill the criteria of ODRB. Some of them their family members have already availed the different schemes for this housing. Nothing, everything, serial number and everything, they have given details of it.
And there
Will
are
you not
also
deal with it?
repetition of names. There are also repetition of names. Those numbers have also been given. Let them respond to this affidavit.
But one thing, Lord, that the person, those are given the PMA houses only.
So the difficulty is because every scheme has its unique features.
Right.
One scheme says that this will be the eligibility criteria, and the person who fulfills the eligibility criteria may avail. But the other scheme may put it a different eligibility criteria. Those persons may not fulfill those criteria. So in that event, you can't equate. You can't.
Selection.
No, sir, you can't. Now means you can't reopen the entire issue. That's the beneficial piece. They have identified 3,047. Fair enough.
Only thing is that those who have been provided PMI,
This can't be done. This can't.
PMI.
You respond to this facts, otherwise we can't. We have to then accept on the basis of this affidavit. No. Huh? We can dispose of. There is no difficulty. But on this affidavit, this is 11th April 2020. No, release it. Yes, come. Take down. The public interest litigation is taken out.
You are not
Nothing.
to observe that in the.
I have seen. I have recorded. For that reason, they were permitted to give an affidavit.
Remember 19 years that take it out.
Released on my person.
Yes.
The earlier products.
Oh, sir, why? Since one of us, my name is not inclined to take up this matter on a personal ground, let these matters,
No, can it be listed?
that will go to the
Small submission.
place before the chief justice for assignment.
Small submission, man. This 12A in two matters are coming tomorrow. This matter, not this matter, but 12A, 12-2, all these mining matters coming tomorrow. So I didn't have a records. I requested the registry as well. They are not
Please, why don't
coming.
you give them
If Lordship allow, then I can get that because
why record of the court cannot be given. No, Mr. TSG. You can make an inspection. We will permit them to make an inspection.
hey, scan copy. If you Lordship permit, then
And what is the utility of the certified copy to be issued?
authorized manner part happening. This paging will not be the bunch
No,
of records.
you can have an inspection, no doubt. You are entitled to inspect the court's record. No
volume
problem.
of papers.
We will
Who
permit
can
you
do
to.
it? I ask next.
May I pray that matter be listed because stay was.
Which one?
This.
No, we will have to. We will have to.
They have filed counter, Internal Department filed counter. Today, right now, they are serving copy of the law. So I think same day time to respond to the counter. So it will want to continue. So the MP model
The senior counsel appearing for the petition.
Interim continues.
Interim order, if there be any, shall continue till the next date.
Second has to.
Don't take.
Petitioner before Lordship, the second has to read. Pursuant to demand notice, he reported entire compensation amount and obtained the environment clearance.
No, you are the second highest bidder. What happened to the first highest?
Refused to execute the work.
Okay.
As per rules 27(9) of the OMC rules, I was allowed to execute the work. As per the direction of tender issuing authority, I deposited the entire compensation amount and also obtained the environment clearance and mining plan. On the date of execution of the lease deed, a communication was made from the Advocate General they are restraining to execute the lease deed. This is the entire scheme.
Why?
And
why it is issued?
They have indicated in the order, one of the bidder whose bid was rejected on the ground of false affidavit, he has approached this honorable court.
Correct.
And that writ application is your lordship available in my case also. WPC number 36487 in the last WPC. In that writ petition, there is no interim order restraining execution of or stay order for.
Who is appearing? Who is appearing in that matter? Yes. Let us hear this matter first. Take care of your matter later on. Yes, you argue this matter. Which one? Which one is yours?
All the three. See, there are four writ applications.
Oh, you are representing Rupa Sindhu Muduli. Why you have filed 3 writ petitions?
Well, I'm saying this. Well, in 2014, the picture of person he was granted the lease of 2 soil sand soil. One was and another Mukundapur. He was granted only 1 acre of land. Though the lease was executed, but he found that it is difficult to operate the so he requested to enhance the lease area units, and it was enhanced. It was enhanced
By a subsequent lease deed?
Yes, Lord. Another lease deed was also executed in 2016.
Yeah. What is the duration?
5 years.
21 it expires.
My lord. Yes, sir. But Milord, it was there, sir. So before expiry of that period, I requested because 2 years I could not
Operate.
Because of the delay in supplying EC certificate and the mining plan. Delay in supply. So it was extended. For 2 years.
So 23 is it expires.
Yes,
21 initial he says in 2016
So, sir,
lease deed executed for 5 years. So 21 it will expire.
Lease deed executed 14. It was supposed to expire on
19. So it was extended till 21.
2 years with certain conditions that he will furnish the EC clearance and other things, which he could not. Which he couldn't.
Then
Milord, it was extended, Milord. Though it was extended, Milord, I could not operate the mining the sand soil, Milord, because lease deed was not executed, Milord. I requested the processor to execute the lease deed, Milord. He didn't, Milord. Then I came to your office, Milord. Why notice was issued? They filed that in the meanwhile your lease has been cancelled. Still, they say they have filed the document, but that cancellation order was not served up to me. Number 1. Number 2, Milord, the Tahsildar is also under the rules. He is not authorized to cancel it. It is the collector, Milord. Controlling authority is the collector. He is the competent authority. He has no jurisdiction under the rules, Milord. It is the controlling authority. Collector could have cancelled their this area. In the meantime, Milord, another Soirat, Milord, Nuaga, Potpur Nuaga, Sand Soirat, Milord, it was like for auction, Milord. I was the highest bidder, Milord. My bid was rejected on the ground that I am a defaulter here in these 2 cases, Milord. In these cases, Milord. But your lordship will find, I will take your lordship's kind notice, Milord, that they have admitted that I have not paid the sand, Milord, for 2 years. That is 14, 15 and 15, 16 years. They have admitted. But even then they say that you are defaulter. I will take it. But if your lordship find that I am not a defaulter, Milord, then I have a case there in his case, Milord.
No.
Because my lease has been rejected on the ground that I am a defaulter here, Milord.
What I gather is, if it was a lease executed in 2014 for a period of 5 years, so that is the normal period would expire in 2019. Since you could not operate from 2014 and 15 because of the EC clearance or this mining lease was not approved by them, they extended the period. They compensated that period of 2 years by saying that you must also give the EC certificate. Did you submit the EC certificate?
It was delayed. It was delayed for 1.5 years.
Why? When you applied?
Yes, in time, the mining director, the deputy director of mines, he supplied the approval, mining approval after 1.5 years. It was not under my control. giving mining plan, my lord, approved mining plan, my lord, it is in the hands of the my director, deputy director, my lord.
So which writ petition you have challenged this and which writ petition is relating to what? Which writ petition? You have filed 12305 of 2021, where you are saying that what is the relief? Give me.
My relief was to execute the
2305.
execute the lease deed, my lord.
Leave deed for
2 years, my lord, that extended 2 years, my lord.
2 years.
Extended.
Correct. So it should have been up to 23.
They should have given but 2 years, my lord. Like what I they have to give, allow, they have to execute the date and they have to like 2 years. my lord.
Okay.
They have 2 years, my lord. What?
Yes. So any interim order is passed there on the matter?
Subject to result of the.
If we see 12305,
Yes.
there is an interim order that any decision taken pursuant to the fresh tender call notice shall be subject to the result of petition. In spite of this order, the subsequent tender it has not been finalized in favor of anybody. Solely because that the present petition is pending.
3178. Follow through.
There is no problem.
This is 3178. This was filed. No, this was in this matter. At the time of execution, there was no interim order.
That was in 12305 of 2021.
Let us see what is the prayer which is made.
My lord, may kindly see that prayer. That is at page 24 of the said petition. In 2025.
Just 1 minute, sir. They wanted to cause the advertisement for auction in relation to Kalasandapur sandbed. And the demand notice also they challenged. Where is that demand notice of 23rd of February?
Annexure 10.
Annexure 10. Can you read it?
No.
Is the English, the copy is given? Translated copy?
Demand notice.
You are challenging that. Let us see the scope. Let us see the scope of the writ. So there are two challenges which is made. First is that the demand is void, illegal, and quash, and also the further advertisement of 16.3. First, let us see demand on what ground. What is I can't, this is in a vernacular language. I can't say what is written there.
This is there also. In English, there is no.
English English.
I am taking your first writ petition 12305, sir. Please, page 54 or 59, I do not know.
54.
54. What is this document?
That is the demand notice. Demand.
What it says, sir?
Area views. Area homes.
Kindly, Leslie, you can tell us.
Even if you read slowly, let us see, we can understand. Yes, read slowly. Atodwara, this is what is the first sentence. Read.
ଏତେ ଦ୍ୱାରା
ହଁ,
ଆପଣଙ୍କୁ
ହଁ,
ଜଣାଇ ଦିଆଯାଉଛି ଯେ
ହଁ,
ଆପଣ
ହଁ,
ନିମ୍ନରେ
ହଁ,
ଦର୍ଶାଯାଇଥିବା ଜମିର
ହୁଁ,
ରାଜସ୍ୱ ଖଜଣା
ହୁଁ,
ଓ ନିମ୍ନ ମାମଲା
ହୁଁ,
ସମ୍ବନ୍ଧୀୟ
ହୁଁ,
ଅନ୍ୟାନ୍ୟ ସରକାରୀ ଦେୟ
ହୁଁ,
ବାବଦ ବକେୟା ଟଙ୍କା ଅଦ୍ୟବିଧ ପଇଠ କରିନାହାନ୍ତି।
ହୁଁ,
ଏଣୁ ଉକ୍ତ ବକେୟା ସମସ୍ତ ଦେୟ ଆପଣ 3/3/2021 ତାରିଖ ସୁଦ୍ଧା ସମ୍ପୃକ୍ତ ରାଜସ୍ୱ ନିରୀକ୍ଷକ ରାଜସ୍ୱ ନିରୀକ୍ଷକ
This is government, here, Rajesh. Revenue.
ଦଳ କାର୍ଯ୍ୟାଳୟରେ ପଇଠ ଦେଇ ପାଉତି ଗ୍ରହଣ କରିବେ। ପାଉତି 30।
Yes.
ଏଥିରେ ଖିଲାପ କଲେ
This is issued,
by the alignments.
no, first broad letter, above notice. Top is a notice, above it, what is written, who has given?
Yes, ରାଜସ୍ୱ ନିରୀକ୍ଷକ, inspector of revenue inspector. ରାଜସ୍ୱ ନିରୀକ୍ଷକ କାର୍ଯ୍ୟାଳୟ. But he is not authorized under the law. To send such notice.
Yes.
He's the only Tahsildar, not revenue inspector.
When that amendment is brought in the this OMMC rules?
2022.
22. Okay.
These are happenings in the 2015.
Oh, I understand. Just asking, just to have a clarity in my mind. So they said that under this rule, there is a area demand of this.
Yes.
Now you'll have to pay to 3,22,000. So according to you, this.
According to us, there is no due at all. I have paid everything.
So how far the writ court will go into this aspect?
The documents are there. They have admitted.
Okay. Show us the document that there is no due.
Minor. Your lordship can see the execution of the deed itself. Annexure 3 at page 32.
Yes.
This is the deed executed between the petitioner and your lordship next page 33. Your lordship can see. In the middle, 2-3 lines from the top minutes.
Deposited 1 lakh.
Deposited, yes, describe part 1 of the schedule and has deposited. The lessee has deposited this.
Sum of rupees 1 lakh 1,000 something for the year 2015 and 16. 2015 and 16.
Final.
Yes. So
16. All the requirements under the law.
Then he say liable to pay another 1,09,000, 30% of the for the year 2014-15.
That I have denied. That I have.
But that lease deed says that you will have to deposit within 15th of January every year. Every remaining.
Yes. That is again admitted.
Yes, show us.
Yes, Lord. You can see. Yes, Lord. Annexure 5, Lord. It is the recommendation of council ATM, Lord, to extend the deed, Lord. Page 40.
Page 40.
48. Post 8.
Yes.
At the bottom, Lord. The detailed practice of minor minerals allowed differing amount of royalty, surface rate, and other dues to be deposited and already deposited have been indicated in the table given below for your information and necessary action. Next page is the
correct.
Next page is the you also can see. This is the important document, Lord. 2014-15, Lord.
Yes.
You also can see quantity limited 0. Balance quantity, all interest royalty, dead rate, and last column, the royalty, dead rate.
Paid as per assessment.
As per assessment.
I got you.
I have paid all. I have paid as per assessment. I have paid everything. They have admitted. So here's the question of dues. I have paid as per assessment. That is why he recommended to extend Millers. You will also kindly see. However, now the lessee is approaching the undersigned to extend the period of lease and allow operating the source as per permission granted by the collector Ganjam.
No, it is said, it is requested that the lessee will be allowed to lift the minor minerals for the further period. The modalities thereof may be kindly be supplied. So it says it does not. That it says that it may be taken into account, consider it. If it is allowed, then necessary action will be followed. Then
Taking into consideration.
Then what the decision was taken?
It was allowed, Millard.
Where is the order allowing it?
Yes, Millard. And it's a 7 Millard.
Show us.
And it's a 51, page 51.
Yes.
In due consideration of your application.
Yes, extending the lease period from such and such.
Extended.
Then you were produce the modified plan and the environmental clearance certificate.
Millard. There is no question of dues, Millard. There is nothing like dues, Millard.
Then what? Then have you submitted the mining plan?
I have submitted the certificate to 1 and 4 months delayed because it was granted after one year to.
Sir, it was granted on 19th of January, sir. What you did immediately after 19th January 2019. 19th January, sir, this letter. Where? Show us that you applied.
My application, there is no dispute regarding that.
There is no dispute. What are you? Have they admitted that you immediately applied? You took time. He is saying that you did not comply the conditions, and therefore it was not executed. That is what the additional government advocate is saying. Show us that you applied. Again, show us that there was a lapses on their part.
That document.
Best he is entitled to refund of that particular amount if there is no fault. Now, yes. Page 52. Very alarming election line. Election line. The second paragraph. Read.
This is it. Counter unit and so the B by 4 units.
We applied only
I thought of geology. Yeah, next one, E/4, counter 31, page 31.
What it says?
Yes, you may read it. Approval of mining plan of mining of Korasundapur sand quarry over an period of 50 over an area of 15 acres. Located in
Sir, we are not concerned with that. Sir, we are simply concerned with the area where the extension has been granted. Now, they have allowed the extension for 2 years, subject to submission of the modified mining plan and the environmental clearance. They are saying that you did not submit the environmental clearance. Time was given that within certain period you'll have to deposit. You did not. So they are not obliged to do it.
They have to bring the mining plan minutes. They have 2 years. Tahsildar, competent authority.
But who will submit?
They will bring and will pay the cost 2 years.
The mining building plan, modified mining plan will be prepared by them.
Then and I will pay the cost 2 years.
So that was done. The clearance certificate will be given to whom? To you? Is a Tahsildar who will apply. The Tahsildar will apply for environmental clearance or you will apply?
Says he will obtain it. May I read that portion of the rule?
Please, it contemplates two situations. If he does not do it within a time frame, then it is you who can apply. Read the provision. Please read the provision.
Grant of query is one. So the rule 27. 3 years. Sub rule 3 years. In case the mining plan or environmental clearance for the proposed lease has been obtained by the competent authority, this fact, along with the cost of obtaining thereof, shall be recoverable from the selected bidder.
In the event it is not obtained, then what is the choice or option given? Give me. Whoever says.
Rule 28, sub rule 3.
Oh, sir. Come. 28.3.
23. 22 I am reading. 22. The competent authority may cause the mining plan to be prepared and approved.
3.
In case the approval under sub-rule 2 has not been obtained by the competent authority, the selected bidder shall cause a mining plan to be prepared from the recognized person and approved by the
So
authority.
what you did, what is that means if he is not, then in that event you can. The liability is also on you. That's why I say the option. So you can't take a shelter that the competent authority is the only authority to obtain the plan or a EC. If he does not, then the option is also given in this rules itself. You can. What you did.
He has not said that he cannot obtain this. The authority has not said that he cannot be. The authority has not said that he cannot obtain that. Because
No, sir. No, sir. No, sir. No, sir. No, sir. The language is not such. No, sir. I have delivered a judgment. That's why I am talking about.
But we have applied.
When?
That is
When?
Immediately.
Immediately.
I
Show us one document immediately. I will show you a document when you applied. Show me immediately. From your own documents which you have annexed, I will show you when you applied. Sir, you did not apply immediately. I am telling you. You sat over the matter for more than one year. You sat over the matter. You did not do anything. Ultimately, only in the month of April 2020, you applied. If you want this fact, I am inviting your attention to page 53. Come to page 50. I'm inviting your attention. Second paragraph, sir.
Considering.
Yes, sir.
The representation submitted by lessee release period of cross underposition is extended for 2 years to the extent. And as per later in the magistrate and the lessee has been asked to submit the revised mining plan accordingly within 3 months in later dated, but the lessee submitted the revised mining plan in the month of. It was submitted council documents, competent documents.
When? Question is when. You say immediately. Immediately means you were asked to submit plan by a letter dated 2019. And when you applied in the month of April 2020, more than 1 year. You say immediate. Is it an immediate? When a lease extension period is two years.
This April 20 is not application, not my application. I have submitted to the council after obtaining the.
No, sir.
My lord, that is the.
What are you talking?
Yes, my lord. But the lessee submitted the approved by the.
Yes.
So it was approved by the.
So why you submitted? Why you did not do it a mining plan within the period?
The mining plan is submitted before the.
Sorry.
The deputy director mines miller, not before the authority miller.
No.
He will approve miller.
No.
No, that is the. He will approve, not the competent authority miller. Approve. The plan will be approved by some other officer miller, not the competent authority miller. That is the deputy director.
Anyhow, we do not find from here. Anyhow, then
I have submitted the.
Now what to do? What to do, sir? Tell me. What relief now in 2025 can be granted to you?
One thing is
Yes.
that if that.
What do you expect?
If the lawsuit decide that I am not a defaulter, that I can in the future I can participate in all wills. But if the lawsuit finds that I am a defaulter, if it is not decided, then I will be debarred from participating in any auction mills.
For all time to come.
This will be there. This obstacle will be there because you are a defaulter there. Like this case, I have not lifted mirrors. I have not lifted. It is admitted mirror. I have deposited all required amount mirror as required under the law mirror.
But you did not deposit the amount for an extended period from 2019 to 2021.
No, that is cancellation. You also can see the cancellation order. Why they have cancelled? You also can see, and it's A by 4. That was the reason for cancellation.
No, the cancellation I understand. He says that you are a defaulter in respect of that lease. So the rule says that once you are a defaulter, then you are not permitted to participate. I appreciate it.
Fine.
Your contention is that there was no default on your part,
Fine.
and therefore this concept of default should not remain, so that you can apply in the future.
Yes, sir.
I understood, sir, when you say so.
Fine.
So you are not very much concerned now, so far as this old concept is concerned. You are now saying that your default should go. That's all. Nothing more than that.
Because they have admitted that I am not.
It's not admitted. Then the demand, why the demand is made? Yes.
And the cancellation is by an authority who has no jurisdiction to cancel. So this.
So now the lease has also gone. The period has also gone. Everything is gone. What more?
That order cancellation.
21.
That cancellation order should go, Millard, if it is unauthorized.
Then what will happen? Suppose the cancellation order is quashed. Then
Go for fresh auction, Millard, so that I will participate, Millard.
they have already gone for a fresh auction.
Millard, pursuant to the cancellation, Millard.
Sir, they have to. Otherwise, suppose if the cancellation order goes,
Millard.
what is the effect?
Effect that is
That the period of lease is also expired. A lease can be cancelled only during the lifetime of the lease. If the period expired, can you? I am finding a very bad example to elaborate the thing. What will happen? That's why I say, suppose a cancellation order is set aside. Let us presume. Sir, please consider. Suppose the cancellation order is quashed. I accept your condition. Then what? Then what is the position? Then what is the position?
That the auction will go, Millard.
Which one? How can it go? How can it go?
And that not being cancelled, Millard.
Sir, the problem is there was no extension deed which was executed in your favor. The extension was made subject to two conditions. The conditions according to the authorities were not met by you. So the extension order actually did not take effect. Question is, again, I am saying, if we say that it does not, if in the meantime they have gone, now if we quash, the period has already expired. Your lease, suppose if it is there, expires in 2021. Can you revive? You can't.
Yes, one case Supreme Court said they
What?
give the 2 years.
What?
In one case,
That was under Article 142. Here it was given to you.
Our High Court has also given.
I do not know whether the High Court can exercise the Article 142 powers which is conferred upon the Supreme Court.
No, the High Court has also.
I doubt whether the High Court can exercise the power conferred under Article 142 upon the Supreme Court.
Article under 46, Millard, they have.
Rewrite the contract for the parties. It is really making a contract for the parties. I know 2-3 judgments against that principle. It says that the court is not supposed to write a contract for the parties or rewrite a contract for the parties, should not interfere in this regard. That's why I'm asking, suppose if we accept the order of cancellation goes, it also is the fact that the normal period has expired in the meantime. And only thing is that if it is there, then at least this stigma which is put on you, as you correctly say, that this stigma should not be allowed to continue perpetually. So your condition. But how this auction will go? It cannot go.
Auction blood in view of the cancellation.
Nothing is there. Till date, nothing has happened. How they have.
No, what the cancellation order has been passed by a person who has no authority to cancel means. Has no authority to cancel.
That's why I'm saying, sir, if we accept your contention, then at best, what relief we can give it to you? We can say that this order of cancellation is bad, illegal, invalid, and therefore is hereby quashed. Let us go to that extent. Understand? Then what? Let us go. It goes. Then what the court will do?
I can participate in all.
That is what you say this will also go. That is what I am asking you. Can it go? Because in the meantime, your period has also expired.
That period is also going to be over.
Because the execution has not been done. They went to execute. The execution was arrested on the instruction of the Office of the Advocate General.
That proposal is also applicable to me.
What?
Execution is prevented. Yes, execution is prevented.
There was a condition. There was a condition attached to the execution, sir. This condition appears to have been diluted to some extent. No, sir. No, sir. No, sir.
Cancellation is done by a person.
Oh, please, I accept a authority who is competent to cancel the lease has not issued the letter of cancellation. Let us presume it is correct. Let us take it by you that we have accepted this. We accept. Then what we can do as a court, what we'll do, we will simply held that this letter of cancellation is bad in law, illegal, because the authority is incompetent. Let us proceed. I'm saying this is the seventh time I'm repeating.
By petition for extension of time and
No, sir. No, sir.
Reconsider.
No, sir. Under no circumstances. No, sir. There is no power of an extension which is provided in the statute. Authorities are doing it. Since it is beneficial, we are not saying anything. Show me. Show me.
Extension power is there.
Show me. Show me, sir.
I'm giving one.
Show me.
One.
Show me. Provision, tell me. And to what extent?
Well, yes.
Yes, show us. Show us. Please show us.
It's when
I do not find they have quoted any provisions in any of the letters. Show us.
27.
Where is the provision where I find the maximum period? Maximum period?
43.
43. Yes, please show us. Yes, 43.
2.
Yes, execution.
The date of commencement of the period of for which.
Just 1 minute. Which one you are referring?
Milord, 2 milord.
Section?
Today, section is a rule milord.
Huh?
40, rule 43.
Show us. Which one? Which sub rule?
No, the Orissa Minor Mineral Concession Rules 2016. 16.
I'm reading. I'm just reading. Yes.
43.
Read.
One. The date of commencement of the period for which the prospecting license.
Which one you are reading? 2016?
Sub rule 2.
Yes. Yes. Yes.
The date of commencement of the period of for which the prospecting license from mining lease or mining lease or quarry lease is granted shall be the date on which a duly executed deed is registered. But what I beg to know, this is implied extension. Plus 5 years.
You have chosen a wrong person.
Right person, whatever.
What it says, sir, then I'm telling you, under the Transfer of Property Act, if you read section 105 thereof, it talks about the leases, how it is to be done. It says that the lease would commence from the date of an execution, or it may commence when it is registered. There may be a different date. An execution can be prior, registration may come later. Under the Registration Act, the obligation is within 4 months or 3 months from the date of an execution, you have to get that document duly registered. If it is beyond that, the registering authority will not register that document. So the execution date and the registration date are two different concepts. Here they have recognized that the commencement of the lease shall be from the date when the lease is registered, not executed.
I'm saying that.
So that means it is a date of commencement of the lease. It has nothing to do power to enlarge the extension or grant extension or grant renewal. No.
Extension, implied extension.
Is it? Then read 110 of the Transfer of Property Act. That's why I'm saying that.
If the lease is granted for 5 years, suppose from 15 to 14 years, and it is executed in 2006.
I'm telling you, sir. Suppose a lease deed is executed unregistered, executed on 1st of April, correct? For a period of 5 years, and it has been.
Now leases are first granted for 5 years, then execution comes. That is why I am saying, if it is executed after 2 years, then automatically it is extended for 5 years.
My concept is different. Sir, a right accrues to the lessee only on the strength of a lease deed. No right can accrue in vacuum. It has to accrue on the basis of a deed. So once the deed is prepared, again I am saying, sir, the distinction is this: whether it will commence from the date of an execution or it will commence from the date of registration is the issue. Normally, the rights of the parties, they are governed from the date of an execution. And under the Registration Act, if the registration is subsequent, it will relate back to the date of the execution.
Not about the execution and registration.
Sir, commencement means what? When the lease right of the parties would be guided or bound or would be subject to the terms and conditions. Suppose a lease deed, they say, I hereby grant you a lease. Lease deed is not executed. It is not there. They say that no, your conduct is bad, and I terminate it. Can they? No, because the contract has not come into the reality. It is a proposal which is given, they have accepted it, and it has to be included by virtue of a concluded contract. A contract may enter, but it's not a concluded contract.
There is no, what
So this is what I'm saying. No, sir. This, no, sir. No, sir. Show me the provision which permits the extension. I think then, okay, I will accept. I will deliver a judgment. Whether it connotes the extension, implied extension.
His application to amend the writ petition challenging the order of cancellation has already been rejected by this honorable court by virtue of order dated 5/5/2025 in the present writ petition.
Then what he challenged in the next writ petition?
In this present writ petition, so far as cancellation, he never challenged.
Then he filed a separate writ petition.
By virtue of counter affidavit.
Then has he filed a separate writ petition?
No.
Then how can you argue?
The facts are before lawsuits. Your lawsuit can.
With deepest of respect, if your amendment is disallowed, can you bring to the notice of the court the fact which you wanted to bring by way of an amendment? Can
Fact was there. Fact was there. Fact was there.
Then why you wanted to amend?
Prayer,
So if the prayer, the relief is denied, then can you seek that relief from us? I didn't know the fact. I'm thankful to you that you brought me, because the way he has started.
And all these
are very difficult, sir.
Before the.
It's very difficult. What is expected that all the facts should be argued by the responsible member of the bar, which is there on record. He should be very fair to the court in making his submission. He can definitely interpret the law. He can definitely assist the court in shaping the law, but he is not supposed to hide any fact. He is not supposed to distort the fact. He is not supposed to.
In fact, I am giving your lawsuit one by one.
Sir, you are a legal expert. I think you are not a veteran in the profession. You have a substantial year of practice. I have the strongest of trust on the members of the bar, that what they say at the bar is definitely there on the record. They will never say something which is not there on the record. That is what, because I belong to that side of the room. I never disbelieve the statement made at the bar at any point of time, but the bar has more responsibility when not to break that trust. You are harping on me, but repeatedly the order of cancellation is issued by an authority who is not competent under the law. Not competent, where you did not challenge by way of an amendment, you want a relief, and that amendment application has been disallowed. Can the court grant such a relief which the court refused to incorporate? No, sir. Not expected.
Subsequently, when
Not
a petition to bring that document.
Sir, amendment has been disallowed. You will bring a document in support of the pleading. But, and the reliefs, when the relief is denied, can you bring those documents?
Whatever is there, not in the, before not.
Sir, then my understanding of law is wrong.
That was not sought on me, my lords. That is why I prayed for your lordship.
Sir,
to
the
direct-
court has
and
refused.
directed them to produce that acknowledgement.
Sir, court has refused to amend. If his statement is correct, I am again relying. I have not opened.
That is there. Lord.
Now let me open. Where is the amendment application filed in this May? Which IO? IA
3893 of 2020.
3893. 38.
2025.
EQRS, where is, everything is dotted. S, then, where is T? Oh, this is S. Where is T? No. IA?
3893.
It's not Pandas.
Alignment time down to internal phase 5, schedule A. (24.8) and my land senior has stated about the opposite parties 1 to 4 file counselor affidavit on so.
No, paragraph 8 is the cancellation. That is what I really meant.
Schedule of amendment minor.
Now, paragraph 8 I have gone. Now I wanted to go into the schedule of amendment.
Internal phase 5. Plea which were advanced, that was there.
To quash the order. Yes, this is there. I got it. Sir, you need not have to. And where is the order rejecting this application?
5/5/2025.
5/5/2025.
6 pages order. Pagina IA number 3893.
5/5/2025.
Order number 18. Order 3, 4, 5, all these contentions were at that point of time.
That portion I have did. Thereafter, I had filed a petition to say that cancellation order was not served on members. I filed a petition, and you also were directed to produce that acknowledgement immediately.
I didn't know at that point of time, this was not brought to the notice that it has already been dismissed or rejected.
Subsequently, I filed a petition to
Sir, it was not brought to our notice, to my notice, that the application for amendment had already been rejected earlier.
No, that order has not been passed by your lordship. Your lordship.
This rejection order was also not placed before the honorable bench.
Your lordship can see it was before
order dated
23/7/25.
Yes.
23/7/25. Not by, I think not by your lordship. Directed to file affidavit, produce that document with affidavit acknowledgement. 23/7/25.
Yes, that's all.
Even if we are the order, that you also, as you also know, the order is not communicated with them. Then it is
Yes.
the non-existent problem. It's a knowledge. Till that they have not filed, produced or filed an affidavit till that, as per the lots of actually. So it was not solved on the. Therefore, I could not challenge in time. So if it is fine, Lord, there is.
So far as this matter of 12305 is concerned, what about the another matter?
Another is same.
12308.
It's same, exactly the same.
Same means in respect of another send query.
Same.
No problem. All the letters are there.
Yes.
Yes. And what about 364847 of 2021?
In that case, where my bid was rejected on the ground that I am defaulted.
Default. Okay. I got it. Yes. Anything you want to improve?
That default amount, if we also decide, then I can be able to at least participate in other. But that is an obstacle for me, Lord. Even though I have paid the amount, Lord, the admitted amount, admittedly, Lord, I have, again, Lord, I want to.
No, you just showed me that letter where they wanted an extension. They have suggested, they have said all the amounts have been paid.
Everything.
I understood.
So when I have paid all the amounts, that is no question of default, so that I can participate.
Yes.
Defaulted amount were deposited prior to the query was put into auction, and the rest part of the defaulted amount was deposited after auction.
Yes.
So on the date he was.
Now you got the full money.
Yes.
You can't deny that you did not receive the full money. Maybe belatedly, maybe something, but now only question is tag. You put a tag on him, the defaulter. Whether that should continue or should not continue.
For this particular auction,
That's the old chapter. For future.
Future, if he has cleared, he will produce all
He
the
has
records and
cleared.
documents.
He has cleared. According to you, partly he paid before this auction and partly after. He has paid the entire money.
My lord, for future, my only respectable submission for future, once a notice is put, once a query is put to auction, then parties have to put their bid with all records and with an affidavit that no area dues is.
This is what then will have to. He wanted that.
Yes.
That once I have already paid, then I should not be kept within the bracket of default.
Yes, well, then at that point of time, if he produces all documents, records that
so far as
clear,
this send query is concerned,
these
two send queries are concerned, he cannot be, according to him, he should not be treated as a defaulter because he has paid all the money, which you are also admitting that he paid partly, thereafter he paid the remaining amount. Now it is the full amount which you have received.
For these particular sand queries, which are the subject matter of these writ petitions.
It is only in respect of that. He cannot be regarded as a defaulter for these. He may have another sand query. He has committed a default there.
Yes.
That is not a subject matter here. The subject matter is these two queries.
But these two queries, the queries were put to subsequent auction by of advertisement, and what has happened thereafter? That is.
But he was not awarded a contract.
He was not awarded.
So So he says that I am not there, but you are rejecting my offer because I am a defaulter. So in future, if any auction is done, at least on that ground that I am a defaulter, I should not be debarred.
Yes, debarred to participate.
That is what he says.
Yes.
That is what he says.
That.
Yes. Yes, you are. No execution.
Till today, no execution base. Only play.
Why you are writing a letter because there was no interim order? No, sir. It was subject to the result of the appeal does not mean is only the principles or a doctrine of lispendence which is attracted here, which should not. Anyhow, why you prevent? Interim order means no execution, I can understand. As in his case, there is an interim order. No lease or lease deed will be executed in favor of anybody. In your matter.
Yes, in my case, it was happened. In my case, it happened.
Yes.
How they commented? Yes, on the basis of communication from the original office. So here also, it will also kindly see only, I don't want to spoil the value time. But there was two demands in respect to Sarah. He is very much aware about the demand made by him. Normally, he filed an affidavit after that, there was no demand.
Oh, he has. Then the state has come up, yes, he has deposited whatever the amount is there. So there is no dues. No dues. Why you are?
Yes.
You are?
I am for opposite party number 6.
And he is opposite party number?
No, he is in another. We are in different.
Correct. So he is also a successful bidder?
He is also successful.
In one side?
Yes, one.
You are in another side.
So item number 1 is 12305 is concerned. We both have participated. He becomes I became successful bidder. He becomes number 1. He says that I have not executed the deed. That is what he should be given. I am concerned on that. I requested counsel that. But
so now you have to argue your case. This beam. What is this? Your client is?
His client is
yes, Beamsen.
Beamsen in my case.
Beamsen is your case.
Sub item number 1.
What is your grievance?
The non-execution of
lease. I got it. Then who are you?
We are all in item in 12305.
Oh.
Since he challenged the subsequent auction notice, so no decision has been taken, though we have participated.
12308, you are not a party.
No, 308 we are not a party. 305 we are party.
So you have nothing to say on this.
In 12305, we have already filed the written note. Along with my written note, I have filed judgment of this Honorable Court passed by a coordinate bench that no extension of lease is permissible. There is no such provision either in the home.
That is what I asked.
That law is there. I have enclosed to my written note.
Oh, I have asked him.
That already
he has relied on 43.2.
Yes.
We'll consider it 43.2.
One thing must make point out, of course, not related to me. My learned friend says that he has deposited the all areas.
Yes.
In one case, we have said deposited the areas, but if he participates in future, in subsequent auctions, then he has to produce records and document that he has no areas. That is what I am saying.
Who will certify that no area?
No areas, they will file an affidavit.
Sir, here it is a case where for a particular period, he paid the entire amount without undergoing or undertaking any mining exercise. He deposited, and thereafter the extension was done on that score that he was prevented from operating. This amount, what you have done? Can you charge?
No, my lord, we are not charging. What I am saying, my lord,
so where is the default?
My lord, I am not on default, my lord. When there will be
no, he's flagging because he does not want him to contest in future because his client.
My lord, for future auctions,
whatever rules.
The only thing is, in this case, it will be that there cannot be any default, and once he has deposited whatever the demand was, then he cannot be regarded as a default in respect of these two Cyrus. That's all.
That is
Nothing more.
Yes. That is.
And therefore, in future, if somebody says for this Cyrus, he will say the court has held that I have deposited. What more? Yes. For orders, keep it in the next week and send the files with the act. Yes, call the next.
Item 21.
T1.
T1. I am appearing for opposite partner 2, 3 and 7. My senior has filed an affidavit enclosing one document of the year 2006. So I have sought for some instructions.
Who are you?
His claim is against me.
Others. Once you say state of Odisha, that conveys a message to me that there is only one respondent. What do you want, sir?
I pressed on time, I will obtain instruction on this affidavit dated 1/9.
Affidavit has been served on.
Yes, on 8/9/2025, I have received the.
So what you were doing for such a
I have sought for this document is of the year 2006.
So what? So
That's
6 years, another 6 years you want
One more week. I pray only one more week.
Why? This is not expected. I just thought that it has been served on you yesterday or
No.
before yesterday or 3 days before. I can understand. Month of September, whole of the September, whole of the October, now in the middle of November.
1 week, I think.
Both parties are
2, 3 and 7.
and which way was it? We take instruction. We list the matter in the week.
Only submission of mine, my lord. In this case, my lord, I have challenged Annex through 1, which order has been passed by the OP number 4, my lord. Here, my lord, the government has filed counter affidavit, OP number 4.
What do you want?
Yes, my lord. The order which I have challenged, that has not been denied by the.
Oh, then what you want now?
So only to that effect, when I am challenging the order, the government be directed to also take instructions because on that day, because in the counter affidavit, they have not.
What instruction? They have already filed their
My lord, in the counter, they have not denied about.
That's all. Let's consider it.
Item number 22.
No, it's a late for the.
26th. 22.
My lord. May I help?
Yes.
In this case, my lord, the present petitioner, for extension of lease period.
Mining lease.
Yes, my lord. Mining mineral.
Again, the same.
Stone quarry, madam.
You show me 44, 43, 2 or something else. Choice.
Manner in last problem. Because my matter is separate manner.
Hello, sir.
Manner. What happened, manner? My lease period, my agreement is executed in annexure 1 manner. Lease period on dated 28/8/2029 to 2/7/8/2024 manner. My lordship kindly peruse annexure 1.
Yes, yes.
Yes, madam.
Perusing. Show me. Yes, it is there. Form of query means for remaining period.
Yes.
Yes, I understand.
And then thereafter, my lord, in the meantime,
your lordship kindly peruse annexure 4 series, my lord. Annexure 4 series. What happened, my lord? After execution of the deed, my lord, the environment clearance I have got it. Annexure 4 page. Running page 57, my lord. I got it, my lord. Yes. Yes. What happened, my lord? I have got a environment clearance for the operation of remaining period, my lord. Till your lordship got it. Operation of order of remaining period in respect of HON'BLE Mahuman Stone Quarry number 59. In pursuance of approval mining plans in regards HON'BLE Stone Quarry number 59 submitted by the mining officer Baripada Circle, Baripada, as per agreement leaded on dated 14/9/2052 and 28
Up to 31st March 2021.
Yes, my lord. My lord. That's yes. What happened, my lord? Thereafter, my lord, I have correspondence more time, my lord, but not issue the environment clearance certificate. Though for which, my lord, I am not unable to operate the mine stone quarry. Your lordship kindly peruse annexure 11, running page 75. The Tahsildar opposite party number 3 admitted, my lord, and issue the letter, my lord, to the petitioner. And this is to inform that the joint reassessment has been conducted on dated 3/3/2022 regarding the actual extraction of the minor minerals from your HON'BLE stone quarry number 59. It is reported that you have extracted 140.50 cube against the approval quantity of
So you have extracted more than what is there.
Less than 5,000.
Oh, sir, 140.
Yes, ma'am.
Okay. Yes.
5,000 for.
I read it 14,000. That's why you. Yes, less.
And 5404 comes stone quarry minerals as approval mining.
You do not have to, sir. He says that you have also paid the royalty for 5704, but you have extracted only 144.
Yes, my lord. Thereafter, my lord, your lordship got the annexure 7, my lord.
Page?
Page 70.
70.
Yes, my lord.
Yes.
My lord. That letter issue from the Tahsildar opposite party to the regional officer, State Pollution Control Board, regarding the consent of the operation of operate the minings for the period of 2020-21, so and so, consented. In the last paragraph, invite to kind reference on subject above. I am to bring your kind notice that Narayan Sav, leaseholder of HON'BLE.
He has said that please give your issue of consent so that he can operate the quarry for the year 2020.
Yes, madam.
Has not been permitted to operate for 18-19.
Yes, madam. Madam, what happened, madam?
Non-execution of the lease.
Yes, madam. Yes, madam. So what happened, madam? Due to non-issue of the environment certificate, madam, the petition is unable to operate 2 years, 6 months, madam. In their
but he prayed for only 1 year, 2020 or 20.
No. Madam, what happened? Every environment issue for the stone quarry, they issue every year, but lease period is 5 years. The concept is, my lord, in my appreciation of the honorable court, my lord, he has executed the 5 years. Due to the official technicalities, they have not issued the environment certificate, my lord. Next upward, my lord, your lordship kindly peruse the counter. They have admitted in the counter, my lord.
This is their letter. So what is the difficulty? Then what?
The difficulty is now. In last occasion, your lordship kindly peruse the last order in my lordship's order, judgment in a High Court matter on dated 7/5/2025, madam.
Yes.
Had so and so, it thus produce some of the order of the court along with the memo. Submit that in case where the fault cannot be attributed to the petitioners for not operating the lease of minor minerals to extension may be granted as directed in the appropriate case. Copy of the same order handed over the.
What is that appropriate order?
Yes, madam. I have filed fax C, madam. Fax C. Your lordship kindly peruse. And another second copy. Sorry. First copy already deposited in this date, but second copy not filed. Flag C. The present petition is discriminated, my lord. Because in this area, they have admitted in counter para 12, 61 queries, my lord. Out of 61 queries.
They have to take a decision, what we can do.
What?
Now the regional
In
officer, the Tahsildar has written, what you have done.
The Rakshit kindly turn to flag.
What is this flag?
Flag. We have filed another affidavit here. Mark flag D, the Rakshit D here. Affidavit dated 9/7/2025.
Oh, E. That's D.
D.
He's citing a judgment. D.
Yes. That is that affidavit dated 9/7/2025. That sequence the paragraph 10 or 12 and 13.
Yes. What? What do you want to say?
Well, the relevant portion is at paragraph 13 here.
It's an admission on your part.
Yes, ma'am.
So,
After receiving that alert, you can take a step.
why is the environmental clearance is not given?
My lord, I am appearing.
Who is for the pollution control board?
My lord, I am for the SIA, my lord. OP number 6, my lord.
What?
OP number 6, my lord. I am, your lordship, I am in virtual mood. Your lordship, I am for the OP number 6, my lord.
Yeah.
What's CRM?
OP number SIA, State Environment Impact Authority, my lord.
State Impact Assessment Authority.
Assessment Authority.
You are the person who has to grant the clearance.
My lord, he has not given an application. After your lordship, the order of the NGT, he has taken a issue from the DIA, your lordship, District Expert Appraisal Committee, which was
I could not hear, sir. I could not understand. We cannot make a head and tail from this. What are you saying, sir?
My lord, in this case,
Your
my lord,
voice is also not clear. We can't understand what you are saying.
your lordship, this is a case where the petitioner has obtained the issue from the District Expert Appraisal Committee, my lord. District Expert Appraisal Committee.
Our attention is drawn to a letter which is written to a state pollution control, whatever body.
My lord, your lordship, no prior EC is necessary. Before getting the pollution control board measure, EC is necessary. Prior EC as per the my lord notification.
So they have approached you.
No, my lord, no application is pending, my lord.
What?
No application we have heard, my lord. Your lordship, 16/4/25 a resolution has been passed
by the SIA, where they have said that the cluster of the mining has been approved, but individual application has to be given to the SIA. Individual
Sir,
application.
what is this paragraph 10? In paragraph 10, the state has said that cluster EC for Kanjamahal cluster was created by SEIAA. I think you are there.
My lord, my cluster is
On 16/4/2025.
My lord, and after that, your lordship, they have said that individual.
Where this sand query number 59 is included.
My lord.
So what more? You have granted.
My lord, your lordship, individual application has to be given. In cluster, the EC cannot be given. So we have said the individual application has to be given.
Sir, it simply says, however, the approval is a conditional upon the preparation and submission of wildlife conservation plan.
Yes, lordship. Just
in consultation with the divisional forest.
Your lordship.
Sir, if the individual is to be granted, then why you have issued a cluster EC?
Your lordship.
Why you issued a cluster EC, sir?
16/4/25, your lordship, a resolution has been passed by the SIA, where they have said that considering the information document furnished by the proponent and the presentation made by the consultant on behalf of the proponent, the SCSC approved the EIA EMP report in cluster approach and recommended the following. The SIA Odisha may consider to grant environmental clearance to individual lease in cluster with specific condition as per annexure after receipt of the individual application from the lessee in cluster along with the following. So individual application they have to give to the SIA now.
Sir, where is the 16/4/2025?
Your lordship,
they are relying on that.
I shall submit.
Annexure D5. Where is that?
Yes, sir.
D5?
I will submit that matter. The recommendation resolution has been passed by meeting. I will submit that, your lordship.
Where?
I will submit that.
Yes.
The relevant portion at page 14.
Yes, that's a cluster, but individually one has to apply. So go and apply.
My lord, yes. Your lordship, kindly prepare the preliminary counter. Just for your example, the mining officer, that is the opposite party. Let us say that, my lord, with the reference of your subject, I am to say that your representation in present petition on dated 2/6/2024 and 7/24 will be considered on merit after obtaining of the cluster EC over the Kanjamahal stone quarry matter. Already considered. They have considered after the interference of the court matter. They have admitted.
Sir, why don't you go? They have taken a decision granting a cluster EC.
Yes.
But they say the individual query holders must apply.
Yes,
so you go and apply.
Yes, sir.
It will be deemed to have been granted because they have already taken a decision to grant it. Only thing is they will put a rubber seal on that.
Yes, ma'am.
Nothing more than that.
But in the meantime, extension of
Extension, they say that the letter is there in your favors. They are saying in an affidavit, we will extend. They have gone to that extent. We will extend the period if you obtain the EC.
Yes, ma'am. Even this.
So everything is given in your favor. You are arguing.
Yes, yes, ma'am.
6 months extension.
2 years, 6 months.
So he has.
Yes, madam, again and again approaching different authority, till today not listening, my lord. 2024 is pending, man. So that's the petitioner is investing a huge amount of this, the operation of this query. 26 years for the extension.
Disposal has to be in that. The petitions. Sir, we will not make any observation that you will come with a judgment that the court has allowed the extension. That's why we were very careful in saying it's a consent and a concurrence, nothing more than that. Yes, next.
Item 23.
In this case, the petitioner is the successful reduction in mining source. After completion of the execution of the agreement, there is a joint inquiry conducted by the authority where
They found that you have queried more.
No. They found that the query approved by the Tahsildar is not feasible for operation due to waterlogging area. There is need of change of site map. Site map, the observation at page 75, they need change of that site due to the
Is a sand quarry.
sand.
So the deposits are there. What water logging? I do not know. The deposits have to be extracted.
The mining department conducted the inquiry and made the report. Thereafter, on the basis of their report, the Tahsildar suggested the change of site to the ADA. And
I do not know. For that, is it permissible under the law? Because for every site, you will have to go for a tender, an open auction.
Sir, execution of the agreement, this thing happened, man. And the Tahsildar's revised map submitted before the authority, they are kept silent. I have approved before your lordship. Since 21st May 2024, your lord, this uncle directed to state.
We can listen to this, still need instructions. But 1 week after your lordship, I will get instructions and.
1 week.
Item 24.
I have received copy of the counter from the opposite parties.
Opposite party number 5, not parties.
By that opposite party number 2, 3 and 5.
All, but here it shows 5 only. So you want a rejoinder?
My lord, very small adjournment, my lord.
Adjournment means?
Well, also keep it in S2 will file it.
So you want a direction to file a rejoinder. What adjournment? It is submitted by the counsel for the petitioner that he has recently received the copy of the counter.
Third December. What is 3rd December? Item 25.
My lord, for a short adjournment since I learned senior counsel has been engaged in this matter and there's a bereavement in his family. Not able to.
One does not stand in the way, my lord, but your lordship kindly see the records, my lord, on how many occasions they have.
This is a way that I give you something from my left hand and take it from my right hand. So there is a bereavement, the needful. So what we will do after perusing then we'll have to dismiss. Because you are opposing. Yes, an accommodation is sought on the ground. Huh?
Zero irrigation canal for construction of its for excavation and construction of their irrigation project. The project was started from
10/1/2022 and completion date is 9/7/2020. In the meantime, the petitioner has already completed and completion certificate has also submitted. But
But they're not making payment.
payment has not been made.
What are you doing?
So final deviation payment has already made, but is a discrepancy in the payment, what is demanding and what it is due. Your Lordship, you have to make a fresh application before the authorities and they'll decide, Your Lordship, because he.
No, he must have submitted the bills.
Yes, Your Lordship. So with regard to his payment, Your Lordship, Your Lordship, we have written to him. He's saying that he amounting to 1,48,50,000 some odd money he's
Correct.
demanding.
Yes.
But we have made it that it is around 9 lakhs of rupees that is being paid, Your Lordship.
From 1 crore to 9 lakhs.
Yes, Your Lordship.
Huge disparity. I can understand small amount. So what is your stand? You have to justify that why this.
We've also annexed to Lordship page 186, that is the final bill of final deviation of bill also that has been also paid to him, Your Lordship. So Your Lordship, let me make fresh application before the authorities.
Just,
let them
just 1 minute. Yes.
Sorry, Lordship's attention to Annex 16, page 64.
Just give me. Give me.
This is a letter from the Under Secretary, Assistant Financial Advisor, the serial number 4. How the tender was invited without forest.
Page 64.
64.
No, I do not.
64 of my read petition.
Yes.
Serial number 4. How tender was invited without forest clearance, violating the quotal provision.
Yes.
How tender has been invited 2021 after 30 years survey and investigation, which was done in the year 1991. The survey was done in the 1991. The tender was.
Sir, where is the clear admission on their part? Just tell me that whatever you have done, they have admitted completion certificate. Show us.
They have already given the completion certificate.
Where is that, sir?
Your Lordship may kindly. Additional affidavit. File. There is 10 learning bill. Your Lordship may kindly come to page 91, Annex 19. Excavation construction of Saharapada Bolabhadrapur minor 12 minor uptaking RD 23805 to RD 252205
Which one?
Minor distributory, including structure of the irrigation project. This is the 10th running bill. Sorry, 9th running bill issued on the date 21/7/2024.
Page.
Page 91 also.
Yes.
Annex 19.
Yes.
This is the 9th running bill issued on the date 7/4/2023. My final bill has not been sanctioned. They have also already, the work has already been completed. They have admitted. And they have also raised that in their counter. Lordship. Lordship may kindly come to page 3 of their counter. That the total amount rupees 1,43,90,750.
Where do I get it? Where do I get it?
Para 6 of their counter. Page 3.
Page?
Page 3, my lord.
Yes.
The petitioner executed the work as per agreement. There is in idle time no machinery employed, the laborers, technical persons employed in the project. Who has executed as per the agreement. Total 1,86,904 is withheld and paid after approval of the final extension of time, and initial
I'm not
security
getting
deposit to be 2,97,200 and fixed deposit to also of SDFC
What-
Bank
where
and
is
the
it?
plans will be released after payment of final bill.
Which paragraph reading?
Paragraph, your lordship, paragraph 6 of their counter appeal. Paragraph 6. Page 3, my lord. Lordship, what? Hey, please, your lordship.
That means you are entitled to more.
My lord. Because there is a deviation in the project. The number
No,
one,
no,
there is a
that says
deviation.
that there was some extra work which they wanted from you. You have also done that extra
My
work.
lord. No, no, my lord.
Because the lordship
As
is the
per their
paragraph 68
direction.
for counter.
But as per the authority's direction, I have executed the work, and whatever extra work has been bestowed upon me, I have also discharged and handed over the project within the time. And the time which has been extended due to their lapses.
No, no, sir. If that is the position, then it requires a voluminous evidence to be gone into. If we find that it is a voluminous, then it is better to go for a civil suit and find it. Show that line of judgment where it says that in a contractual field where the voluminous evidence is to be gone into, some experts have to be done, then it is better to relegate the parties to civil court than you don't know. Line of judgment.
Friday. Friday.
What Friday?
Friday.
There are a series of judgments on that score.
Friday.
No, sir. Go for a civil suit. Go for a civil suit.
Should be kindly observed, I will make an application, the authority will consider. I have the deviation of the.
They have already taken a final decision. What more application?
The project has been deviated.
True. They have said that whatever the deviation, whatever the things we have done, there was a proper management. In paragraph 16, they have said measurement was done. And as per those, the payments have already been released. There is nothing. You do not agree with this. That no, there is some extra work which you have done. They are not agreeing. You prove it.
The petitioner is not genuinely that has been stated in their
No, sir. No, sir.
And the
No, sir.
paragraph 7, it is humbly submitted that the final
No,
decision
sir.
has been
We'll
approved.
pass the order.
No supplementary
Sir,
equipment has been done.
We'll pass.
Done. As per the direction of the authority, I have carried out the work. And there is
True. They are not denying that you have not carried out the work. Please consider. But they are not agreeing the measurement which you are giving and the measurement which they took are tallying. According to them, this is what the measurement I have made the payment. If you have done work more, prove it by going there.
my security deposit and my other deposits, which they have kept, they have not released.
That they have to release.
That make
Why you are not releasing the security deposit? Why security deposit is not released?
Since he's raised up, will your lordship?
So what? So he wanted something more from you. When you have already discharged and paid, then why you will not release the security deposit?
In my letter, I have stated in my letter, annexer, your lordship may kindly come to annexer.
Sir, you want a judgment to be delivered now? I will deliver it.
Your lordship, as your lordship, this is, I don't.
Sir, it can't be done. There are a series of judgments of the Supreme Court which says that when you have to prove something, By virtue of a many documents, the evidence has to be gone. Commission is to be conducted. Commissioner has to be appointed to ascertain everything. These are all civil matters. You go and challenge it. And so far as the EM, security deposit is concerned, and all this money, you have to refund because you have no grievance. You have not raised any grievance against them.
AIR 1996 Supreme Court 3515.
Justice, there is a subsequent judgment of Justice Sinha also.
Yeah. State of UP versus Bridge Corporation, Bridge and Roof Corporation.
Bridge and Roof, I know, but there is a subsequent judgment of Justice Sinha as well. They have to relegate to a civil court. Yes, I'll dictate yours. Yes. Call the next.
Sorry to disturb the schedule, that item 40 we was mentioned in the morning.
Yes. What is that item 40? Why? It is a hearing matter.
No, my lord.
Then why?
There is a order which has been passed because on the first date, the FCI corporation said that they had no plans to transfer the employees because the contract labor issue was there if your lordships was there. So if your lordships can take it up tomorrow at 2 p.m. subject to your lordships.
It can't be done in this way.
They have already issued the order for transfer when the writ petition is pending. 3 days back they have issued.
Who is for the other side?
Mr. Naik was appearing. He knows I had told him in the morning that to be taken up at the last on the board.
.43 also somebody was saying.
40 and 40. Subject to lordship, 2 p.m. Subject to lordship, sir.
No, first matter. You
First
argue.
Leave
Both. Oh, admission day. Okay. No, what I have said, I am just going to do it because I find that I am not able to justify many. So only the fresh admissions concerning the mining will be taken up on 2 days. Fresh matters. So far as the PIL are concerned, it will be taken up on 1 day in a week. And I am now distributing like today, all the hearing matters I will take up on a particular day. You argue the matter, hearing, so that we can dispose. So urgent matters.
This is on the interim only because the IA has to.
Anyhow, that is
Subject to your lordship.
Sir,
I live
interim application, how it is to be dealt with is, leave it to me.
Tomorrow.
Do it for the time being. From the next week, do it that on Wednesday, the hearing matters will be taken up. On Monday, it is the mining matters, fresh matters for admissions. Those will be taken up. No hearing matter will be on that day. And then Tuesday, you just send it, the PIL matters will be taken up on Tuesday. And Thursday is a tax matter will be given a first preference on that. And Friday will be the another, the broken benches. Yes.
Item 27.
Your lordship, kindly see the order dictated by lordship 12/11 also the order dictated 7/2.
What? Yes.
What's going to the order passed by this honorable court? I have obtained the instruction for it. Here, removal of the encroacher. The IIC Cuttack Sadar Police Station. He has given instruction that after assessment of the situation on 31/2025, after 31/1/2025, no requisition has further been moved from the mining officer. And this letter I received on 18/11. Lordship may grant me time till next week so that I can speak to the mining officer regarding, because this deed has been executed in favor of the petitioner, but because of the resistance by some miscreants over the leasehold property matter, he could not able to carry out the operation. So once police force went there, but somehow they could not, then assessment was made, 5 platoon police force is required, but further requisition from the mining officer has not been received by the police.
Why it will be? It is a duty. When the police found that I am unable to do it, then it is his duty to assess that how many police personnel are required.
They have assessed.
They have assessed, then they will do it.
Requisition by only they are waiting for the requisition from the mining officer.
Mr. DSG, how many paramilitary forces you have there in the Cuttack?
Allow me till next week.
Yes, how many paramilitary forces?
Yes, Cuttack, we have a unit of CIC in Mundli.
How many? Armed? They are armed? Tackle the emergency situations?
BSF, in CSF, the CRPF is most capable. There is a big.
So how many battalions you have? CRPF?
CRPF, we have a strength about more than 500.
More than 500. So can you deploy near about 200? Can you provide 200 persons? Because I find the police administration is not in a position to tackle.
Which matter?
There is one matter which is
I'm
just inquiring because you are a DSG, the Deputy Solicitor General. So central forces, at least you are responsible.
Yes, yes.
So you have the adequate numbers.
Yes.
We are directing. Police personnel are not really very equipped.
They will do it.
They are not in a position to do that.
Requisition from the mining officer.
So apprehensive. A person who have been granted a lease is unable to enter. And the police says that I will let me assess the situation. What assessment?
They have assessed the situation. 5 platoon of police force is required. Only mining officer has to put a requisition to the police authorities. So your lordship may grant me 2 weeks time so that I can.
If the commissioner of police is prevented by several persons from entering into his office, what he will do? You will assess the situation. How many platoons are required? Tell me. How many platoons are required to remove that persons so that he can enter into his office? This assessment that shows that you have no, I would say, the gel to do it. You just wanted to linger on. That is what the impression this court had gathered.
Since 2023, they are also saying I have annexed tax for deployment of forces. 2023. I am for 2020, 22, I got the leave. Now,
From 2024, the writ petition is pending for this fringe issues. And a person is unable to just step into his mine because there are some persons who gathered there and prevent him from entering there. Don't then remove that particular query from the purview of this query purposes. Don't auction it to anybody. Let these persons, they take over the charge. Not expected. Because he is a fringe person, not very significant or a celebrity. So, of the No, that is his submission. I do not want. What is their opinion? We wanted an amicus curiae to step in and submit their suggestions.
We have also filed, we attached the judgment of the matters High Court, which has also dealt with the issue. And also we have suspicious many more things.
Give the copy. Oh, yes. Suggestion from?
Page 5. Page 5.
Fine. No, I appreciate, but I also want something do's and don'ts. Where they can use, where they cannot use, what prohibits, what
But that part that is
permits.
the act and the rule. The rule clearly said the word, what are the provisions are there in the rules, and that. That will be.
Where is the rule annexed?
Yes, sir. State Government of India Prohibition of Improper Use Act 2005.
Yeah.
And the rule 2007.
Is annexed to your petition, which page? Flag?
That is that, this state of the.
No, flag. Huh? E.
No, that is not a petition.
It is in page 14 of our
Counter also.
counter.
Huh?
Intergovernmental counter is also. Act they have also annexed to this. Defenders have also filed from this document, like circulars and all that. You also will get that act in state, central government counter at page 7.
And flag? By Ministry of Home Affairs.
Yeah, yes.
This is a preliminary counter.
Preliminary counter.
Plan B. Internal page 7. Internal page 10 this.
So this is what they wanted, that it should be displayed along with the Satyameva Jayate.
Yes.
And only standalone will not do.
Yes, sir.
And it should be done in a Devanagari script.
My submission, I give the suggestions how to implement the lordships and farm page 2 here.
No, they have given a very exhaustive suggestions. They say that how it has to be done, how the white publicities can be done.
The same thing has been done. They also followed my learned senior what is there submitted in lordships. And I want to be show you.
Have you annexed all those circulars issued by the Ministry of
Yes, sir.
Home?
Annex of 4. Page 18 of the counter.
Apart from this, after filing the case, we are also communicated the commission to all the chief secretaries of the state. Said you have to strictly adhere to, and if any violation is there, take necessary action as per the statute. There is a penal provision in the statute itself. That was also intimated to this. Basically, Karnataka High Court judgment.
I think there has been a rampant sale of the miniature of this without that Satyamev Jayate written.
Agenda section 3 your lordships.
We'll pass the order ultimately. We will not keep this matter pending. We'll discuss and then don't keep it for orders. We will give the date.
No, currently, the submission.
What?
Little lot of submission.